differences are. All right. All right, so moving on to key terms. I want to make sure that everyone's aware of the meaning of these terms as we go through this presentation. So firstly, equal access. What we really mean by that is that your student is entitled to equal opportunity to participate in and benefit from educational aids, benefits, or services. And this includes not just in the general education setting, but in whatever setting they're in, whether that's special education, whether it's in pull-out services with providers, they are entitled to equal opportunity. Um, Second key term is FAPE. That is a shorthand for free appropriate public education. Um, FAPE refers to the provision of specialized services to facilitate the educational needs of students with disabilities. The provision ensures that all students have access to a proper education, regardless of their ability or disability. And so that's very important as well. Third key term is placement. Now, placement refers to where and how the educational program is providing your student with that FAPE. And placement is something that impacts all students, disabled and non-disabled.
And continuing with the key terms, reasonable accommodation. So, reasonable refers to changes made to ensure that equitable or equal access to benefits, regardless of ability. So, this is a critical piece of supports in the 504 plan, is reasonable accommodation. So, and then moving on, you have reasonable modifications, which is modifying the curriculum. So, the difference, and we can think we'll get into this a little bit later as well. But with an accommodation, that would be more like extra time on a test. Like the test itself is staying the same, but you're getting a reasonable accommodation that you get an extra half hour to finish it. With a reasonable modification, you're modifying the actual content of the test. And so with the modification, that is what's provided through an IEP as part of the special education services. And then lastly, related services are the support services offered in schools for students who have special needs. So these can include counseling, diagnostic services, transportation, speech therapy, occupational therapy, physical therapy, etc.
All right, so this is a handy dandy graphic here for eligibility. Now, the way that I like to describe eligibility to folks is it's a little bit like a nesting doll, right? You open it up, there's the general population of students, and then within there you have a slightly smaller nesting doll of students who would qualify just for a 504. And then within there at the very center, you have students who qualify for an IEP under the IDEA or for a 504. And you know, some folks don't share my opinion, but I like to tell families that, you know, I really don't believe that one plan is necessarily better than the other. Some folks think a 504 is best. Some folks think an IEP is best. The way that I look at this is that it's all about finding what plan is best for your student, and that really changes student to student.
All right, then so starting off with some of the key differences between these two plans. So both an IEP and a 504 plan focus on helping your child access what's called FAPE, a free and appropriate public education. And the main difference in eligibility is how your child accesses that FAPE. And so whether it's through accommodations in the general education setting, through a 504 plan, or do they need not only accommodations, but they need those modifications and special education services through an IEP. And like Megan said, it's not necessarily that one plan is better or the other. It's that, they really treat a different profile of students and what the needs are, what the services are. And so the legislation surrounding IEPs is the Individuals with Disabilities Education Act, otherwise referred to as IDEA. And then the legislation surrounding 504 plans is Section 504 of the Rehabilitation Act of 1973, which we simply refer to as Section 504 for short.
All right, so let's get into the compare and contrast part. There are different components and protections for a 504 versus an IEP. And they can be very critical when you're determining with your child's team what is the appropriate plan for them. So I think it's probably best, let's start with the similarities. So if you look at this chart, there are some pretty concrete similarities across the board. The purpose, right, is the same. You want to make sure that you're supporting your student, whether they have a physical disability, whether they have mental or cognitive conditions that impact their access to FAPE. Regardless of that, the purpose of a 504 plan and the purpose of an IEP are the same, and that is to support your student so that they have appropriate access to FAPE. Now, with FAPE, both plans are 100% free of charge to eligible students. So what that means is, for example, let's say your student is on an IEP, and as a part of that IEP, they have pull-out services with a speech language pathologist. The school is not going to charge you $50 an hour, $100 an hour, whatever that fee is for a speech language pathologist. Those services are free if they're included in the plan. These are legally binding documents, and that's really important for y'all to know. And the reason for that is that schools have to follow what is outlined in that plan. Once the plan is drafted, once it's completed, once parties are moving on and implementing that plan, you have the right to enforce these plans if the school isn't doing what they're supposed to be doing. And we'll get into that in a bit about what you can do. Ideally, in an ideal world, I always say, Jacqueline and I wouldn't have a job because schools would do what they're supposed to do, and you wouldn't need us. But in the event that you have a student on one of these plans and the district is not following the plan, there are steps you can take, and we'll talk about that momentarily. Um, Now, neither plan is set to continue after high school graduation. These are for K-12. You don't have the right to a 504 or an IEP in college. There are different machinations that you can utilize to get accommodations. However, your student will still have general protections against disability discrimination under the ADA. And I know that's going to be talked about down the line as well. So in terms of the way an IEP and a 504 plan are developed, it's also very similar. You're going to have a team meeting, and that team is going to include important members from the district. That includes your students' teachers. It may include, for example, I used a speech language pathologist in my earlier example. If your student has speech needs, that speech language pathologist should be there. Typically, you'll see an administrator, such as a principal or a vice principal. You'll see a school social worker, other support staff. If your student has a paraprofessional, that person should be at the IEP meeting. And in my opinion, most important of all is you. The parents should be there as well. So that team works together to develop this plan. And I'm sorry, I think I'm delayed. I don't know, Jacqueline, I don't know if you're going or not. I'm sorry, guys. There's delay on my
Oh,
end.
sorry, I wasn't sure where you wanted me to pick up. So, um, I'll kind of pick up where Megan left off, and I'll go through kind of this pink chart on 504 plans. So as noted, 504 is grounded in Section 504 of the Rehabilitation Act. And with the 504, it allows for a more broad definition of eligibility of it, what is a student with a disability. So unlike IEPs, which you'll see have a very specific category that students have to fall into, with a 504 plan, the student simply has to have a disability and need accommodations to have equal access. So it's very, very broad. And then with a 504 plan, that's going to describe again those school specific accommodations. So we're not going to be modifying anything. It is just going to be providing accommodations. Technically, a 504 plan can also include services. So you can get social work, speech, OT if that's needed to have that equal access. However, most schools are very resistant to this. Usually, if a student needs a service, the school is gonna put the student on an IEP, or they're gonna claim that they can't through a 504 plan, but they can if it's necessary. So again, that goes into the supports to access the general education curriculum. So other accommodations besides kind of extended time or testing is maybe the student needs a slant board for writing, or maybe they need an assistive communication device, something, or access to an what's it called? The goodness gracious, I'm losing my mind this morning. elevator, goodness gracious, I want to say evaluator, the elevator, because they're in a wheelchair, they're on crutches or something, they'll get that. And with a 504 plan too, it doesn't necessarily need to be in perpetuity. So if maybe you had really bad surgery and so you're now in a wheelchair for 9 months, you could be on a 504 plan for those 9 months just to have access, to some of those physical accommodations that you'll need. Maybe you need someone to help wheel you around the school. Like you said, need the elevator, things like that. And lastly, the evaluation for a 504 plan can be less formal. So they don't need to have to go through a huge comprehensive process. The evaluation is less formal, and technically, the 504 plan doesn't even need to be in writing and it doesn't need to include parents. Most schools will, as a matter of best practices, both have parents included and do it in writing, but under the law, they don't have to because 504 is really just about providing those accommodations for equal access.
Thanks, Jacqueline. And in regards to IEPs, as we talked about, those are developed under the IDEA, so it is a different statute developing those. Qualification for an IEP is a bit more stringent. So there are 13 specific disability categories that are laid out in the IDEA, and in order to qualify for an IEP, your student must qualify under one of those categories. Some of those categories are very broad. One that we see a lot is called OHI, that's other health impairment. It covers kind of a broad spectrum of disabilities. It's one that I see schools use most frequently to place a student on an IEP. But just be aware that that is a hurdle that exists with getting a student an IEP that does not exist for a 504 plan. Um, Now, the main difference, from my perspective, between an IEP and a 504 plan is that a 504 plan provides, like Jacqueline said, really just more accommodations. And there are accommodations that can be put into place to help a student with access to a general education curriculum. An IEP is more focused not just on services, but also providing special education in some shape or form. It doesn't necessarily mean that your student would have to be in a special education setting all day in order to qualify for an IEP, but there's typically some provision of special education services that makes that IEP necessary. And an IEP does have more stringent requirements. There are going to be specific goals and specific services, as well as data gathering, because you're going to need that data in order to track your students' progress. And the district should have mechanisms and methods in place to do so. And that's something that comes up frequently at IEP meetings versus a 504, which, as Jacqueline described, is a little bit more fluent, a little bit looser. And with an IEP, that requires a formal evaluation for special education services, which is a more in-depth process. And typically that gets reviewed on a yearly basis. There should be an annual IEP review if your student is on an IEP. You may not need that if your student is on a 504. And so those are the main differences between. All right, so let's talk accommodations versus modifications. Um, oh, I see the poll has popped up. I'm going to go ahead and X out of there. I don't know if you guys can see that. Um, accommodations versus modifications. So this is what I was getting into with IEPs versus 504s. The goal of an accommodation is to ensure that a student has equal access to that general education curriculum and classroom to the greatest extent that they can. And so it's assistive measures. For a lot of students, I think I probably speak for Jacqueline and I both when I say the one that we see the most is extended time on testing. That's an accommodation. Now, a modification is something that changes the curriculum or the school environment itself. So, like I said, that's either the pullouts, special education, a change to the curriculum in order for your student to get that FAPE. And so those are the main differences. Now, what we have in the middle of this Venn diagram is that there's a similarity in that the purpose is still to help the student succeed. The purpose is to have that student get that access to FAPE. And they can be implemented. You can have accommodations and modifications as part of an IEP, as part of a 504. I will tell you, you will generally see modifications with an IEP. You don't typically see that on a 504. Typical accommodations can be things such as I discussed, extended time on schoolwork. It can be scheduled breaks during the day. Let's say your student struggles a bit with sensory issues. Maybe they get a little bit overstimulated. There can be sensory breaks or accommodations that focus on sensory needs, such as one thing we see a lot is access to a fidget spinner or another kind of fidget item. There can be access to sign language interpreters or assistive technology. Braille is a big one. That is an accommodation. Where we shift to modifications is when we see changes in instruction. That can be things like a homebound. Let's say your student is ill and needs to be homebound. That's a modification because it's a change in the instruction. It's a change in the environment as well as a change in how they're receiving the curriculum. There may be environmental modifications. Maybe your student is pulled into a smaller classroom. Certain students that have more difficult disabilities may be in a self-contained classroom all day. Um, Things like online versions of books, that is a modification as well. And so these are things to think about as you're weighing what your student needs. You can work with school staff to figure out, are we seeing that they need modifications or are we seeing that they need accommodations?
Hey, Megan.
Yes, I'm sorry. Can you hear me?
Hey, yeah, this is Mark. We're gonna push that question again because a few people didn't get a chance to answer it.
Oh, sure.
So let's just take a quick pause and we'll push the poll question and then but it'll only stay up for maybe 30 seconds or so. So
Sure.
if you don't know the answer, just take your best guess. This isn't, you're not getting graded on the quiz. So yeah, if everyone could just take a minute and answer the poll question, and then we'll and the answer may be coming, through your presentation. Thank you, Megan.
All right. Thanks, Mark. Let's see. All right. I'll turn it over to Jacqueline for a discussion of the ADA.
Oh. Mark, do you think that was a long enough pause for everyone to answer the poll, or do you want me to wait another minute?
Yep, that was perfect. I think it went away.
Okay, perfect. All right, so moving on. So we discussed obviously Section 504 and the IDEA. There's one other civil rights disability law, which is the Americans with Disabilities Act. And so this one, it's related to IDEA and Section 504, but as I'm going to go over, it's slightly different. So where IDEA and Section 504 um, both focus on education and have that free and appropriate education requirement, the ADA does not. ADA, also like Section 504, is really strictly a anti-discrimination statute. So what it's saying is that the schools cannot discriminate against students with disability and cannot deny them that equal access to participation. So requirements in the law, the ADA extends coverage of Section 504 not only to schools, but it also extends it to employment, public and private educational institutions, and other applicable agencies, regardless of the presence of federal funding. So with Section 504, that's really only going to apply most often to public schools or private schools if they are accepting federal funds, whereas the ADA, it really doesn't matter if they get that federal funding or not, they are not allowed to discriminate. Definitions in the law, essentially the same as 504 for who counts as a student with or person with a disability. But also it extends to those associated with a person with a disability. So if you are discriminated against as a parent because your child has a disability, that would be prohibited under the ADA, but that wouldn't fit under Section 504. Once again, it protects all persons with disability and services provided. Same as 504. It's going to be focused on the accommodations that allow the student equal access. So no modifications, just how do we get that student equal participation or benefit from program or service.
All right. So now we've reached the critical point here. What can you do? You know your rights. Let's say your child's being discriminated against at school, and you're like, what do I do next? They're supposed to do this under the IDEA. They're supposed to do this under 504. They're not doing it. Don't despair. You have options. So there are some main players here. There's the Department of Education Office for Civil Rights. Now, this is a federal option, so it applies in all states. As Liz discussed in her presentation, things at the federal level are not great right now. We did have 12 regional offices for OCR. I believe they're down to 5 now. But it currently still exists as an option, and it's one that we encourage parents to consider. You can file a complaint with OCR if your child is on a 504 plan. They have the authority to conduct an investigation, and that is going to include a parent interview with you to talk about what's gone on. It also includes the OCR caseworker investigating with the district. Um, if they find that there is a violation, they can issue corrective action. And that includes things like ordering training so that this doesn't happen again with another student on a 504 plan, which is often something we hear from parents. They'll say, we want to make sure this doesn't happen to another family. This is one way to have your voice heard and ensure that that change occurs. Now, you can file with OCR if your child's on an IEP, but typically we see a state complaint as the more typical and the more common path forward for those students. So you also can contact, if you're in Michigan, the Michigan Department of Civil Rights. In Pennsylvania, that I believe is called the Human Relations Commission. And I double checked that, but if I'm wrong, Kathy, please feel free to jump in. Now, these are basically state versions of the federal OCR. And so you can file a complaint of discrimination with them, and that includes, of course, Ohio also has a Department of Civil Rights. You can file a very similar complaint of discrimination with them. Now, one thing I want to make you aware of is that they don't simultaneously investigate. So you'll want to make sure that you choose one to go forward with. And whether that's your state Office of Civil Rights or the federal Office of Civil Rights, that's completely up to you. And once you file with them, they'll conduct an investigation. I won't lie, it's not great news. Those investigations can take a long time. I have several complaints with OCR that have been over a year that they've been open. That's normal. Unfortunately, it's just a part of the system that we're in. And like Liz said, we just have to kind of work with it. But the most important thing to Jacqueline and I is that, folks go into this with eyes wide open and they know what to expect so that they can feel empowered in this process. And now you can
Also, really quick, I want to just do one more caveat on the state civil rights complaint. That one needs to focus specifically on the discrimination aspect. So with OCR, you could bring in Section 504's FAPE requirement because OCR is looking at the federal anti-discrimination statute. At the state level, because they're more looking into your state anti-discrimination statutes, focus more on just the discrimination piece. My child has a disability for equal access. They need extended time. They weren't given extended time.
Absolutely. Thank you, Jacqueline. And that's 100% correct. And I know Liz mentioned in her presentation very briefly that Michigan has a pretty comprehensive civil rights law called the Elliott-Larsen Civil Rights Act. And that just as an example is something that you could point out if you were filing a complaint with the Michigan Department of Civil Rights. You would want to point to that instead of Section 504 because of that, because it's state versus federal. Now, your third option, and the one that we see most often with students who are on IEPs, is to file what's called a state complaint. And that is a complaint to your state's Department of Education. Now that in Michigan is the Michigan Department of Education Office of Special Education. I've got all the acronyms for Ohio and Pennsylvania here. These are for IDEA related complaints. This would be, in our best recommendation, the places to go if your student is on an IEP. Now, typically there are sort of two options for the complaints that you can file. You can file a due process complaint or you can file a state complaint. Now, in my practice, what I typically recommend is filing a state complaint. And the reason for that is that, number one, it's a faster process generally. It's also most cost effective for families. Number two, because the due process complaint is a lot more difficult to prevail on, in my opinion. Just as an example, I practice here in Michigan. So in Michigan, if you file a state complaint and you get it to MDE, they will investigate. They'll conduct that parent interview, very similar to OCR, and they will get you an answer within 60 days. That's a pretty good timeline. And I find that we're able to get some success on state complaints with findings against districts. A due process complaint is a little different. That mirrors essentially a court trial. So with a due process complaint, when you file that complaint with your Department of Education in your state, um, and typically what will happen is if you do not resolve through mediation or an informal resolution, you will end up in a hearing before an administrative law judge. And that hearing is like any civil hearing, one in which parties can have attorneys. The district will always have an attorney, and parents can bring an attorney as well. You can cross-examine witnesses from the other side, you can testify, and you can bring forward witnesses of your own and present evidence of your own. And that can be a very empowering process for families, but it is also extremely strenuous, and it takes more time. So typically we recommend a state complaint if you're just seeing this is what's in my student's IEP, they're not following it, and we want them to follow it.
And this is everything that Megan just went over, the differences between a due process and state complaint. So I won't worry about repeating what she said. But does anyone have any questions?
There are a few pending questions. All right, we have, so one attendee asked, I've observed several circumstances where students at charter schools are not provided appropriate accommodations written into their IEPs due to the negligence of the school. Perhaps so the school can get around providing students with FAPE, but still follow the document. Is there a remedy for this, specific to charter schools? Would that be an investigation, oversight to ensure students have the appropriate accommodations written into the documents?
So I would say that's something that we see that's really unfortunately not just limited to charter schools. We do see a lot of times that schools in general will limit accommodations for a student, or they'll be very vague in their wording. Like you said, they really kind of want to get around their responsibility and be able to say, "Oh, well, we provided it as written." So remedy for that is obviously request, and I would say first step is to request a new IEP meeting with the school. Ask to record it so that way there is a clear record of what was said, what was discussed, where you can reiterate kind of what accommodations are needed, why they're needed, and then make sure that even if the school doesn't grant them, when you get a hard copy of that IEP back, that they're included on the notice page of options considered. And then from there, yes, if the school is still not agreeing to put those appropriate accommodations on the plan, and that could be either a 504 or an IEP, then you would file, either a civil rights complaint for a 504 plan or a state complaint for um, an IEP, which you could also do the due process for an IEP, but just to say, look, this is what my student needs. This is what the school is offering. It's not appropriate, and ask for a decision on what's actually required.
Thanks,
Excellent, thank
Jacqueline.
you. And another question, is it
Yeah.
advisable to file a state complaint with, it says OEC, but as well as with the Office for Exceptional Children, which is a specific office in Ohio for the Department of Education. But is it advisable to file a state complaint as well as a due process at the same time? And I think that really is independent of state is the question.
Yeah, so I'll take that one. I would say that I think it's generally not advisable to file a state complaint and a due process complaint at the same time, particularly if they're about the same issue, which I imagine they would be based on this question. So what I think the advantage of having these two separate avenues is that you kind of break it down into something that is this an issue that needs to be determined by a judge? Or is this a clear-cut violation that MDE could easily investigate and determine? So what I mean by that is for example, let's say um, your student is on an IEP and the district is saying that they want to place your student in a more restrictive placement, such as a self-contained classroom. You don't feel that's necessary. They make the unilateral decision to place your student there. That may come down to a decision that you feel is best brought before an administrative law judge to see if it was really necessary. Now, if you have, for example, a student who I've used speech language pathology throughout this presentation, so we'll stick with speech. Let's say you have a student who has speech services, but the district hasn't administered those services in accordance with the student's IEP. Let's just say, for example, that your student has 4 sessions with a speech language pathologist once a week, 4 sessions a month, let's say, so one every week. And during the last 2 months, they haven't received more than one a month or two a month. That's an issue that is very clear cut. MDE can look at your student's IEP, they can look at those service logs, and they can make a very quick determination. So that's something I would say you're best off to file a state complaint. When you file both a state complaint and a due process complaint at the same time, I think you risk overly complicating the issues, not only for MDE or for the ALJ, but for yourself as well. I would say it's always best to streamline and to just pick the appropriate path from the outset.
Thank you, Megan. Another question in the chat is, what are the different reliefs that can be sought in a state complaint versus a due process complaint? So that's the first part of the question. I'll stop there.
So I guess I'll answer that first part and we can just go back and forth, Megan. So different relief is in terms of compensatory education. So, your student is going to be compensated X amount of hours of resource room time or that speech language therapy time. That would be the same in both training. So with the state complaint, usually it'll be broken down into two different remedies. So there'll be a student action plan of what is the school going to provide that specific student to compensate for their violations. So again, that comp ed. For the student, maybe if there's a transportation issue, they have to fix transportation. Maybe they have to hold a new IEP meeting or do a new evaluation, but whatever is required to kind of address the violations for this specific student. Then the state complaint will also include a more broad corrective action plan for the school, which will usually involve requiring them to update and change their policies, provide some training to staff. Those are probably the two main ones. With a due process complaint, I would say, well, you could ask for those same things from the school. Typically, the remedy in due process complaints does and tend to be more specific to that individual student and their needs. So one difference with compensatory education is sometimes, even if not through a decision, through the mediation process, especially through due process, we are generally not always, definitely not always, but more often able to get comp ed into like a fund where the parents are able to use a private provider to provide those compensatory education services. So the school is going to, using Megan's example of speech language therapy, the school is going to set aside a fund of $2,000 and the parent can go to a private provider and that private provider will send the invoices to the school. With a state complaint, they're usually not going to order that. They're going to say the school will provide these compensatory services. Also, with the due process complaint, the biggest benefit is that if you are successful and you are the prevailing party, you get to get your attorney fees back. That's not a remedy through the state complaint process.
Great. I think you answered the second part, but the third part says if a child moves to a new school before they are filing any of these due process or state complaint, is it still something to pursue?
So, Megan, do you want me to just finish this one?
Yeah, that's totally fine. Yeah, feel free.
Okay. I would say potentially. I guess it really depends on what the issue is. Like if the issue for the complaint was that the school failed to do a proper evaluation, that may not be worth it because you're already moving. But if the issue is, again, using Megan's speech language example, that they missed, 20 sessions of speech and language therapy, that might be worth it to pursue because that was very clearly a violation specifically by that previous school district where compensatory services would still be a benefit to your child because it's compensating for that loss.
All right, barring any other questions from those assigned to the Q&A, I think we've worked through them all.
Mark, can I ask one question specifically because we have Megan and Jacqueline here? We have someone on the chat who's asking about the certificate of completion in Michigan and a student's entitlement thereafter to get some services. We know
It's
once a child graduates, they're really not entitled to that FAPE anymore. Can you guys speak specifically in Michigan to that certificate of completion?
Sure.
Yeah,
So,
so a certificate of completion, it's not a diploma. Oh, sorry, Megan.
oh no, no, you're okay, Jacqueline.
It's not a diploma, so they're still entitled to services until 26 because they haven't graduated. They haven't gotten a diploma. That certificate of completion, it's more, I mean, it's essentially a participation trophy as far as I'm concerned. I mean, it's good because it shows that the student, was in high school for 4 years, but they didn't actually meet anywhere near the requirements for graduation. So they would still be eligible for service.
I have a question too, if that's okay. And I already know the answer, but I think it's an important one that we hear a lot. Um, if I have a student or a child with a medical diagnosis like autism or another developmental disability, does that mean they automatically qualify for a Section 504 or an IEP? And if so, why? And if not, why not?
sure. And Renee, I'm sorry. Can you repeat that last part of your question? It cut out on my end, but I don't know if it did for everybody else.
It was just if the student has a medical diagnosis, do they all automatically qualify for a 504 or an IEP? If so, why? And if not, why not?
Sure, thank you. So the answer is no. They don't automatically qualify. Um, and in fact, I've had students with diagnoses in place that districts will do a special education evaluation and then say, yeah, we don't think that they need it, even though they're diagnosed with this disability, whether that be autism spectrum disorder. One that I see a lot, whether it be for IEPs or 504s, is ADHD. And oftentimes, depending on your district, they may not take that diagnosis seriously enough to think that your student may need accommodations or modifications. So that's why I stress to families, and Jacqueline, feel free to weigh in too if you feel differently or if you feel the same. But personally, in my practice, I always tell families you want to take that initial evaluation and initial request for an IEP and for a 504 very seriously, and you want to come prepared with more than just a piece of paper from the doctor saying this student has X disability, whether that be a medical diagnosis for ADHD or for a physical disability as well. Like Jacqueline brought up the student who needs access to an elevator. You're going to want to bring more than just that piece of paper from the doctor. You're going to want to come prepared with information. So for an example, let's stick with my kiddo who has ADHD, right? Particularly in teenage girls, the way that this manifests is in not so much an inability to focus, but in time management. We see that very often with young students who are struggling with ADHD. And you want to come prepared with a series of bits of information for the district saying, this is how my student is struggling with this. Not just that she has ADHD, but because of the symptoms of her disability, this is how it's impacting her access to FAPE. So with that same example, we've got a student who, let's say, is high achieving, but really struggles with that ADHD. And one comorbidity that we see often with ADHD is anxiety. So now we have kiddo who, because of the poor time management associated with her ADHD, is now struggling with anxiety. And that is a self-feeding cycle, right? It increases the student's difficulty in achieving success in their education and getting access to the FAPE. So you want to come with those examples. You want to say, hey, my student was in Mr. Jackson's English class, and she completed her diorama or whatever the project is, and then she didn't turn it in for a week. And that's that executive dysfunction. That's a symptom of ADHD. And they're not going to get that real life example from just that medical diagnosis. You want to bring what you're seeing in your student into those initial evaluation meetings. You really want to provide that information upfront and consistently, because it's not enough to just have a doctor say, this student has a qualifying disability. They have to need some kind of assistance, modification, or accommodation to access FAPE in order for them to qualify for one of these plans. And we all know, right, if your student has one of these qualifying disabilities, odds are that they they do need that help. But it's not enough to just have it. You really need to be able to demonstrate it. So like I said before, document, document, document. Data is your friend. It's better to be over prepared than under prepared, if that makes sense. And I think you need to bring all of that information into those initial meetings in order to qualify your student.
All right, we have another really good question. This is, I'd be really interested to hear what stands out to you about how special education law works in the different states you practice in. So maybe both of you can then talk a little bit about Michigan, and some of the others of us can chime in about other states. The question continues, are there any unique aspects, either in the case law, how cases tend to play out, or what tends to lead to success in these cases that make each state a little different?
Megan, are you okay if I start with this one?
Yeah, sure. Yeah, please.
All right. So in Michigan, I hate to be a Debbie Downer here. I feel like it's very difficult in Michigan. I feel like we are constantly on an uphill battle, really just to explain the law to our judges, and they don't always understand it or apply it. So it's really frustrating in Michigan. And I can't speak to Ohio or Pennsylvania, but I used to do some cases in New York, as well as I think I had a case in New Hampshire and a case in Connecticut. So like the Northeast states. New York is insanely different. And what was really interesting about New York is you have New York City, which is also its own like entity as far as I'm concerned, and then you have the rest of New York State. So it's different there. And the example I'll use, and this has actually been coming up in my caseload increasingly, is unilateral placement. You have a student that would really benefit from a private placement, whether that's just a private day school or just a residential placement in general. And again, in Michigan, it is unfortunately next to impossible to get it. I have cases where I've been successful at like partial reimbursement for private placements, but that's usually the best I can get in Michigan. In New York State, it's almost like they just write checks like candy compared to Michigan. As long as you have a good enough reason, it's much more common. And I wonder if part of the difference there is in New York and in kind of the Northeast area of the country, there's just a lot more options for day schools. Like when I practiced in New York, they have schools specific for students with dyslexia or learning disabilities, schools specific for students with autism. So I think the options are just much more available. Whereas in Michigan, the options don't exist. And then with like New York City, what's really interesting is I assisted on some due process hearings there. Half the time, the school doesn't even show up. So you're getting these like default rulings in favor of the parent because the school just doesn't even bother to fight it. And they're just like, okay, sure, we'll give all the comp ed, and the compensatory education amounts are in the high hundreds of how many hours are being awarded. So it's just really amazing. That was probably the biggest shock to me, was just seeing the numbers in New York compared to how hard we fight in Michigan to get like 60 hours of comp ed.
Yeah, I
Yeah,
could speak to, I'm sorry, Megan.
Oh, I'm sorry, Mark. No, I was just gonna say I echo everything that Jacqueline just said, and I think in Michigan, this is part of why I love that we do what we do, because our goal ultimately is to improve this system for students. But I think we do have a long way to go in Michigan as opposed to other states such as New York. I don't think there's any state yet that's perfect with their system, but in Michigan in particular, I think that districts often win at the due process level, even when the law says that they shouldn't. And that's an issue, I think, both with training of our ALJs and also just with, frankly, I think they haven't been really challenged very much in the past. And so districts are candidly, I think, quite used to winning. And so the biggest thing I think that parents can do in Michigan is to continue to use their voice and speak up and file these complaints, because that is ultimately how we're going to make change progress. But I would say, I think compared to other Midwestern states, even, Michigan is a little bit more difficult to win those battles.
Yeah, I'd say it kind of all comes together a little bit, because I think one of the reasons it's been challenging, specifically in Michigan, I'd say it's more challenging in Michigan for a parent side attorney than it is in Ohio. But I think one of the reasons is because the parent side bar, this group of people we have here today, hasn't really been developed. And of course, school side bars have existed since the 1950s and 60s. So, they've been well represented. Decisions have come out in their favor. And even though all these state complaints and due process decisions are not necessarily binding on another because they're so fact specific, they are influential. And schools have been able, and their council have been able to point to these decisions in their favor over time and say, see, this is how one of these should come out. So it definitely is an uphill battle, but I think getting some decisions over time in our favor, the parent and student side favor, I think has been helpful. And I'd say too that the school side bar makes a lot of difference. I think there is a real tendency in Michigan and sometimes in Pennsylvania for the school side bar to dig in their heels and just say too bad. That isn't necessarily the case in Ohio, but you can run across attorneys where that happens. And but probably less so. So yeah, definitely all of the things that Jacqueline and Megan said, plus kind of the history of success on the school side, I think is influential in all the states. And I think, let's see, I think there's another question. Let's see.
Yeah, and I also just wanted to jump in that I don't think this was said, but another difference between some states, it's only a few states, but for example, in Ohio, Michigan, and Pennsylvania, where we're talking about right now, the burden of proof in these cases is on the student and the family to prove that the school denied them a FAPE or did whatever they did. Whereas there are a few states, I can't name them right now, but there are a few states where the burden of proof, if a student files a due process complaint, is actually on the school to prove, yes, we did provide a FAPE. And in those cases, it's always more difficult when you're the one with the burden of proof to have to prove something. So it's obviously harder than in Ohio, Michigan, and Pennsylvania, as the ones being on the burden of proof being on the student and the family, rather than being on the school. So those states would have it a little bit easier. I think we do have 2 minutes and there is one more question. If you got, and you guys have been handling a lot of great questions. So if you've got the brain capacity for one more, it says in Ohio, if you get and so this is more Ohio. I know you both are in Michigan. So Mark and I can answer this if you can't, but it says in Ohio, if you get a good complaint investigator, you will get good results. However, there is dysfunction at ODEW, the Ohio Department of Education. A parent stands a better chance filing due process in Ohio. School side bar in Ohio can dig in their heels among a handful of attorneys. So not necessarily a question, but more of a comment that in their experience, it can be a little bit better to file due process than a state complaint in terms of Ohio. I don't know if you see anything similar in Michigan. And go ahead, Mark.
I would just say, yeah, I agree with that 100%. And it does, sometimes it's it's the roll of the dice when you file a state complaint. It could, even if it seems like the law is entirely on your side, you can get an outcome, which of course is binding on that family. So that can be very challenging. So 100% agree.
Yeah, and I would say I think that really highlights where we're at in terms of the different experiences state to state. One of the most important aspects of your child's education is frankly which state they grow up in. And it's funny because in Michigan, at least in my practice, my experience has been very different in that we're typically more successful on state complaints than with due process. And I think a big part of that is that generally, I think, like Jacqueline mentioned earlier, the ALJs may not necessarily have the best understanding of the law or may not be educable on the law that applies to your student. Whereas a state complaint with MDE investigating, we typically have better outcomes for families with that. So I think it just varies state by state.
And I would actually disagree a little bit with Megan. I think, and I would agree with what we're seeing in Ohio. Is I see it here too, in the state complaints I filed, that it does depend on the investigator. I think we are more successful in state than due process, but I think it is still a roll of the dice. Most recently, and this speaks to kind of what Mark just said about, even when you think you have a really clear cut issue, is file the state complaint on child find, where the school has a proactive responsibility to locate, identify, and evaluate students suspected of having a disability. My client, met with the school as early as October, November with issues with behavior related to suspected ADHD and said, these are all the things I'm seeing. There's issues with reading comprehension, asked about an evaluation for something. And the school just kind of brushed it off. They were like, oh, we'll put some things in place, but they never did. And then finally, there was like numerous email communications with teachers, with other school staff, again, citing those same behavior concerns and, saying, should we do an evaluation? And actually, I don't think they brought up an evaluation again, but still just putting the school on notice, like these are all the signs of a disability. And then in January, I actually gave the school a complete report of disability diagnoses, and the school ignored the report. It wasn't until the parent submitted another evaluation request at the end of March that the school finally evaluated. And then that determination is still pending. But to me, that was clear-cut child filing. The school had all the notice in the world of a potential disability. And instead, the state complaint blamed the parent for not asking sooner.
Hmm.
So that
All
was
right.
very frustrating to get.
Well, thanks, Megan and Jacqueline. That'll take us to the end of time. For our attendees, if you haven't completed the evaluation for this session, please do. And then we're going to regroup at 10 after 11. Thank you both.